There's a major legal battle brewing that could shake up the National Firearms Act, and it's headed straight for the highest court in the land. A challenge to the NFA's long-standing restrictions on short-barreled rifles, yeah, we're talking about SBRs, is now sitting before the United States Supreme Court and is scheduled for conference. But here's the twist. With Congress recently passing legislation that effectively sets the tax on suppressors and short-barreled rifles at $0, thanks to what they're calling the Big Beautiful Bill, this case may be on the verge of taking a very different turn. Let's unpack exactly what's going on. So, as I just mentioned, there's a significant case challenging the National Firearms Act, and it's made its way all the way up to the Supreme Court. The case is titled United States versus Rush, and it aims to overturn the NFA's regulations on short-barreled rifles by arguing that these rules violate our constitutional rights under the Second Amendment. The petition is also pushing the court to finally step in and resolve the growing chaos in the lower courts over what kinds of firearms are actually covered by the Second Amendment's plain text. Interestingly, the former administration under President Trump has formally waived its right to respond to this petition, basically saying, "We'll chime in if the court asks us to, but otherwise, we're staying quiet." Because of that move, the Supreme Court has added this case to its calendar for a closed-door conference scheduled for the 29th of September, right at the beginning of the next term. But here's the thing, that whole scenario might now be shifting because of brand new legislation that just passed. With the $0 tax now official thanks to both the Hearing Protection Act and the Short Act rolled into that massive new bill, this could end up altering the course of United States versus Rush. So now, we've got to take a closer look at how this legal fight, and NFA challenges in general, could evolve under this new political and legal landscape. For those who haven't been following the case closely, here's the background. Mr. Rush is currently facing charges for allegedly possessing a short-barreled rifle that wasn't registered under the National Firearms Act. His legal team is arguing that the NFA's registration mandate steps on the rights protected by the Second Amendment, and they've now taken their fight to the Supreme Court. Specifically, they're asking the justices to overturn the lower court rulings and rule that both the National Firearms Act and its short-barreled rifle restrictions are unconstitutional. The key legal question before the court is whether the Second Amendment guarantees the right to own unregistered short-barreled rifles that are commonly owned and used for lawful purposes. In support of the petition, the National Rifle Association points out that ever since the court's ruling in Bruin, lower courts have been all over the map when trying to apply the new constitutional test. The definition of what qualifies as a bearable arm under the Second Amendment has become a central issue again. The petition emphasizes that this case brings several key disagreements between lower courts to the surface and provides the Supreme Court with a prime opportunity to settle them, particularly when it comes to identifying which types of firearms fall under the Second Amendment's umbrella. Even though this case is focused on short-barreled rifles, the broader implications could ripple into other legal battles, like those challenging bans on certain rifles and detachable magazines. According to the petition, the right to keep and bear arms applies to all firearms that can be carried, and that includes short-barreled rifles, which are not rare or exotic by any means. The National Rifle Association backs this by citing that there are at least 532,000 lawfully registered short-barreled rifles in civilian hands across the country. They also take issue with how the Seventh Circuit Court brushed aside this widespread legal ownership as irrelevant. In response to all of this, Solicitor General John Sauer, representing the federal government under the Trump administration, told the Supreme Court that they're waiving their right to file a response unless the court specifically asks for one. Shortly after that announcement, the court updated its schedule to include this case for a private conference set for the 29th of September. However, even though it's on the calendar, there's still a chance the justices could ask for more input or supplemental briefs before or after that date. All of this started unfolding before Congress passed what's now being called the Big, Beautiful Bill. But with that new law on the books, the legal landscape is shifting fast. As many of you know, there was a big push in the legislature to scrap the National Firearms Act's restrictions altogether. What ended up getting through was a major win in its own right: the $200 tax that used to apply to suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons has now officially been brought down to zero. And that change is creating fresh opportunities to legally challenge the NFA itself. Recently, Gun Owners of America teamed up with the Firearms Regulatory Accountability Coalition, Palmetto State Armory, and Silencer Company to file a federal lawsuit in a district court down in Texas. More lawsuits are expected to follow from other pro-gun organizations. In this Texas case, the plaintiffs are asking the court to rule that the NFA's registration and transfer mandates for these now tax-free items go beyond what Congress is constitutionally allowed to do. Their core argument? Since the government is no longer collecting a tax, Congress can't rely on its taxing power to regulate these items anymore. As part of that claim, they're asking the court to stop the Bureau of Alcohol, Tobacco, Firearms, and Explosives from enforcing the NFA when it comes to suppressors, short-barreled rifles, and similar arms. Remember, the whole enforcement structure of the NFA has always been tied directly to the tax code. With that in mind, here's what this means for the Rush case we've been talking about. First, the Supreme Court might ask the parties involved to submit additional briefs that explain how this $0 tax affects the legal arguments. On the other hand, the justices could decide that the core issue has been rendered irrelevant by the new law and send it back down to the lower courts for reconsideration under the updated language. There's also a strong chance they simply decline to take up the case at all, and instead signal to the lower courts that they need to revisit it in light of these new legislative changes. Make no mistake, this is a fast-moving, unsettled situation. With the tax on short-barreled rifles and suppressors now officially gone, many other lawsuits challenging the NFA's constitutionality will need to be adjusted or possibly refiled. Judges are likely to require new arguments and fresh evidence to reflect the fact that the statute's tax basis has changed. We'll be keeping a close eye on how this affects the Rush case, and also how it might play into other pending lawsuits, like the Peterson suppressor challenge that's currently before the Fifth Circuit Court of Appeals. Another big question mark is how the Trump administration will respond if the Supreme Court requests a formal briefing. I could see them arguing that the registration system and restrictions still pass constitutional muster, but at the same time, they might concede that the court needs to finally weigh in on whether short-barreled rifles and other regulated firearms qualify as arms protected under the Second Amendment. That's an issue that's been hanging in the air for a long time now and has caused major division in the lower courts. So yeah, this is a fluid, rapidly changing legal situation. The recent $0 tax reform has shaken up the battlefield in a big way. I'll be sure to keep you posted as new information surfaces. In the meantime, you can support the channel by hitting that subscribe button and checking out my site at armscholar.com, where you'll find the free legal survival guide, merchandise, and daily firearms deals. Also, swing by the new channel, the Armed Scholar Armory, for gear reviews and range reports. Thanks so much for tuning in. Make sure to like, drop a comment, and subscribe. And never forget, this country was built by armed scholars, and it'll be preserved by them too.